Thank you for being on time. I see a lot of students, which is excellent, because what we are going to talk will be very interesting for those who study domestic and international criminal law. And we touched upon some of the issues already yesterday, when Kunle asked me the question about the ICC and the lack of multilateralism and the challenges to multilateralism. So I promised the audience already yesterday to address a question which I want to ask all the panelists to think about. Why the major powers, United States, Russia, China, India, and others, oppose the Rome Statute for the International Criminal Court. We have a long history, and briefly to say that the internationalization of penal code law was very much taken in the 1920s and 1930s. Actually, Rashmi and I were part of a project looking at the dawn of the discipline when international criminal law really started, with some courageous lawyers in Poland, in France, in Russia, back in 1930s, who created the Committee of International Criminal Law. And they met many times, and they discussed how to harmonize the criminal law of the European countries, mostly at that time. And they did quite a good progress. They talked about various crimes, including barbarity, vandalism, and others. Lemkin wrote a paper for the conference in 1933 on that, a famous, Polish, but also born in Russia, lawyer at the time, who, and others, Rapoport, Maslovsky, Depela, they wanted to see harmonization of domestic legislation in criminal law. So a lot of work has been done. I think the book is published already by our editors. Yeah. So it will come very soon, but we wanted to look at how the personal lives of those lawyers at the time affected the development of norms in international criminal law. After that, you will hear from the panelists about the tribunals for former Yugoslavia and Rwanda, where Rashmi also used to work, and the Rome Statute for the International Criminal Court, which came in 1998. A significant achievement, I must say, probably one of the best in my lifetime achievement in international law is the adoption of the Rome Statute, but also sharing the disappointment that major powers were reluctant from the beginning until now, so many years later, 20 years later still, the court is underpopulated, under-efficient. And we'll talk also about universal jurisdiction, which is another avenue to seek accountability for heinous crimes such as genocide, crimes against humanity, war crimes, and civil war, crime of aggression, and so on. If the International Criminal Court doesn't do the work, and domestic court, and we have examples. Hissène Habré, former dictator of Chad, being prosecuted in Senegal. We have a case of Pinochet back in 1998 when he was arrested in London. And Lords voted 3-2, a famous decision to extradite Pinochet to Spain. This didn't happen because the Minister of Interior, Jacques Straw at the time, decided that for medical reasons, Pinochet was too old and apparently not able to defend himself in a court, to send him back to Chile. But those interesting materials from our work with Steve Marks and other panelists back in 1999, 2000, resulted in a suggestion how domestic prosecutors can take such cases. We put guidances for prosecutors to use the universal jurisdiction as another avenue to prosecute such crimes. So this is, I think, the scope where we are. We have excellent panel. I think the usual gender diversity is very much signified in the names in our panel. We have Tatiana Volcheskaya, our colleague from Kaliningrad, Kasim Balarabi, associate professor in the Jindal Global Law School, who will tell us more about the African perspectives, and can an African regional tribunal be another avenue to apply the universal jurisdiction or to cooperate with the ICC. Rashmi Raman, assistant professor in the Jindal Global Law School. Stephen Marks, everybody knows him, I don't need to repeat what everybody knows. Distinguished professor from Harvard and senior advisor to the Vice Chancellor. And Professor Amit Bindal, assistant professor in the Jindal Global Law School. We will go exactly as the names are in your programs, and I will keep an eye on the clock because we are told to be strict and disciplined with the time and finish by 11 o'clock. Tatiana, my co-chair, will speak next.
Дорогие коллеги, мне хотелось бы остановить внимание на том, что в Российской Федерации научные исследования проблем Международного уголовного суда, международной юстиции активно стало развиваться только последние где-то, я скажу, 15 лет. Стали появляться монографии, стали появляться, защищаться диссертации. В то же время проблема состоит в том, что учебная дисциплина Международный уголовный суд в Российской Федерации федеральным стандартом не предусмотрена.
Dear colleagues, I would like to emphasize one moment that actually the scientific research on the issues of the penal code, international code, started developing approximately about 15 years ago, and the discipline at the university is not still exists in the standard, in the federal standard of educational standard for lawyers.
И в настоящее время многие университеты включают в свою программу международное уголовное право, как правило, в качестве отдельных курсов для студентов международной специализации, что не есть хорошо, поскольку, я полагаю, специалистам, которые изучают уголовное право, специалистам криминальных наук, вот эта дисциплина, Международный уголовный суд, была бы необходима.
And universities, as their own will, they might include, and some of them include this discipline as only for those students who are specializing in international law. And I think this is not quite a good trend, because I believe that the students who specialize in criminal law would also need to study this.
Я выскажу свое мнение. Полагаю, что это возможно из-за того, что такая существует и, может быть, превалирует точка зрения в отношении того, что Международный уголовный суд – это больше политика, а не право. И юристам здесь, собственно говоря, уже отводятся вторые роли.
And I would say that I think that this is because they say that mostly this topic, the international penal code, has more of the policy here rather than the law, and the law has kind of the second role here.
Поэтому я с большим удовольствием выслушаю результаты ваших научных исследований в отношении этой проблемы. И второе, что я хотела сказать, что я хотела отметить, в плане сравнительного правоведения, если сравнивать уголовное право России и уголовное право Индии, то, если можно обозначить кратко либо в своих докладах, либо потом в дискуссии, такие вопросы, которые связаны с судебными возможными ошибками судей, с оправдательными приговорами, а также с проблемами назначения судей.
I would be glad to hear the results of your scientific research and what you prepared for us for this discussion and for this panel. And also, in addition to this, maybe very shortly during your official panelist time here, or maybe during the discussion, you could expand a bit towards the comparative aspects of criminal law in India, Russia, and especially in India. Might say a few words about such things like maybe judicial failures. Or judicial errors, right, and about the appointment of judges in India also. Оправдательный приговор.
Acquittals. So basically what Tatiana wants to hear is how in India is dealt with judicial errors, acquittals, appointments of judges and so on. Thank you.
Это интересно и в том плане, что я больше 10 лет являюсь членом квалификационной коллегии судей, которая назначает судей на должность, которая решает дисциплинарные вопросы в отношении судей. И хотела сказать, что вот число оправдательных приговоров в России снижается год от года.
And it is especially interesting because more than 10 years, I'm the member in Kaliningrad. I'm the member of the Judicial Qualification Board, and I can tell here that the number of the acquittals in Russia is getting from year to year is getting less. So I think these moments would be interesting to hear from you too.
Okay. Thank you very much, Tatiana. So we move to Kasim, please. Go.
How many minutes do I have?
Okay, let's say, I don't know how many, 10? Let's see how we go.
Okay.
5 minutes.
All right. Thank you very much. My discussion is going to marginally respond to one of the questions you raised as to why these world powers are not actually parties to the current ICC Rome Statute, and also to highlight the politics behind international criminal justice systems and how these politics impact on the domestic prosecution of international crimes. So that's actually what I intend to focus on briefly. And I will preface my discussion by making reference to an article that was published in the American Journal of International Law, which was titled Reflections on the Prosecution of War Crimes by International Tribunals, where the author, Theodore Meron, a former judge of the ICTY, after examining various incidents of international crimes, which shocked the world, from the brutal regime of Pol Pot to the Saddam Hussein exterminations of the ethnic Kurds, from the genocide in Rwanda to the massacre in Darfur, from the ethnic cleansing in Bosnia and Srebrenica enclave to the attacks on the Kosovo Albanians, and from Sierra Leone to Uganda. He actually stated that the world has continued to witness malevolent deeds which surpass understanding, despite legacies of the Nuremberg proceedings, in spite of the increasing interest in the international and mixed tribunals, and also in spite of the unprecedented interest in international humanitarian law and international criminal law. So he posed some questions like, since such atrocities still continue to occur, what is the legacy of the Nuremberg tribunals and the later international institutions which were established, and whether we can still call them success? So my view concerning this is that I think the legacy that was left behind by these international tribunals was actually more of political than legal. Now, I know this is controversial, this is arguable, but examining actually what happened from the first time the international criminal tribunals were established up to the present day, it appears that politics continue to play a very, very important role. So the influence of politics has actually given the impression to many states, including the African state, which I will concentrate on, the idea that the international community did not actually portray sufficient political will to ensure that international crimes were actually prevented, or that all perpetrators of international crimes were prosecuted. So there was actually no clear, sufficient political will to address issues of impunity. Rather, from what I have seen and from what I have analyzed, those mechanisms were used by those who established them to either intimidate or to promote their own political interest. And that's actually connected to one of the reasons why most of those states are not parties to the current ICC statute. Now, I am not trying to dismiss all the important contributions made by these international tribunals. Because of their work, we have now been able to see that we have now been able to identify categories of crimes which will be considered international. We have been able to know their ingredients. We have been able to know how to prosecute them. We have been able to know defenses which are valid and which are invalid. But that is not really the idea that I'm trying to focus on in this field. In my view, the political legacy left by this court has actually influenced, to a greater extent, especially in the context of Africa, the continued occurrences of these mass atrocities. And I will explain why I think this way. So I think that what we are actually witnessing today at the level of domestic criminal justice system can validly be claimed to be a continuity of the precedents set by those international criminal tribunals during the formative years of international criminal law. The systems, the politics, and the approach established and promoted by those states seem to have been sustained continuously at the domestic level. So my discussion is going to offer a perspective on the basis of my appreciation of the whole situation about why international crimes still continue to occur and why we are still not able to address issues concerning prosecution of those crimes at the domestic level. I will be using Africa as my reference point. Now, I will say that the political influence which prefaced the establishment, the operation, the working of those international criminal tribunals have impacted directly on the conception and the operation of domestic criminal justice systems in the context of international crimes with specific reference to Africa. I will try to point out that there are many legacies left by those courts, which we can conveniently categorize into two. There is the jurisprudential legacy and there is also the political legacy. And as like I have said before, the jurisprudential legacy has been very, very powerful. Actually, we have been able to know a lot about international criminal law. We have been able to know a lot about international humanitarian law. And we have been able to also know how to prosecute those things. But what I see as a very, very strong, influential point or issues on the part of the state in terms of domestic prosecution of international crimes is the political influence left by those courts. Now, we do know as students and scholars of international law how politics influence international law. We cannot but recognize the controlling force of politics in the way and manner in which international instruments are conceived or international instruments are drafted. And this, at the domestic level, I mean, in law courts we know that arguments are supported by law in order to secure conviction, for example, but at the international level, it is actually politics that controls what arguments will be advanced by states, and if what is going to be adopted is not in the interest of the state politically, obviously those things will not see the light of the day. So I think an observation of the surrounding circumstances behind the establishment of international criminal tribunals such as the Nuremberg, the ICTY, the ICTR, the Special Court for Sierra Leone, the Extraordinary Chambers of Cambodia, and those other mixed tribunals, including the framing of international crimes, the selection of situations and cases, the selection of judges and prosecutors. I think one thing that is very clear to me is that political interests dominate and control the course of action taken by those who established these tribunals. The selectivity and the bias demonstrated clearly indicate a lack of sufficient political will by the international community to prevent international crimes from being committed, or to ensure that all those who have committed those crimes were prosecuted. Now, we can see the reflection of politics. If I am to start from the International Military Tribunal for Nuremberg, this tribunal was established by 4 powers: the United States, United Kingdom, France, Soviet Union, and they were also represented by their judges and by their prosecutors. The main idea is to prosecute major war criminals of the European axis. Now, while the establishment of the tribunal itself is political, the selection of situation and persons to prosecute was equally, in my view, political, because that particular tribunal was merely to prosecute major war criminals of the Nazis, and those also were politically selected as to who will be presented before the tribunal. Similar procedure was adopted by the International Military Tribunal for the Far East, where we know one of the Indian jurists, Judge Pal, actually refused to take side. He posited that both sides have committed the same offenses, and that the trial was a sham employment of legal process for the satisfaction of a taste of, for a revenge. So it was clearly political. The way and manner in which it was established, the crimes which the court was to prosecute, was clearly framed with the German war criminals in mind, and with the idea of showing that they were the perpetrators, without really taking note of the fact that those world powers actually also participated in the commission of those crimes, but they were never prosecuted. Now, 50 years later, the Security Council established the ICTR and the ICTY. The position here was a little bit different. In the case of the ICTY and the ICTR, the situation was selected by the Security Council. But the cases, that is, in the case of ICTY, it was limited to the former Yugoslavia. In the case of ICTR, it was limited to Ugandan genocide incident. But that prosecutor is considered to be independent, though is to operate within a very restricted jurisdictional framework, and that he is not to receive or to seek instructions from any government or any sources in selecting those cases. Now, we do know that the Security Council is a political body, and that its decisions or its resolutions are actually determined by the political interest of at least the permanent members, those with veto power. So there, from what I have seen subsequently, if their interest is going to be at stake, then obviously none of them will agree to allow such situations to see the light of the day. But then, even if we say that the prosecutor is independent, but then when we look at the way and manner in which the cases were selected, can also be actually said to be political in nature. Why? Because of his refusal to investigate the NATO bombing incidents, which comes within the jurisdiction of the court because of the influence of those powers who were actually supporting the court, and there is no way they will continue to be able to do that if their own states have been implicated in those things. So the refusal to investigate those things was actually as a result of the political consideration there. The ICTR has also been criticized by, for example, Amnesty International for its failure to prosecute the Rwandese Patriotic Front that have actually committed almost somewhat similar atrocities after the genocidal regime was overthrown. The Special Court of Sierra Leone also, although it was an agreement between the United Nations and Sierra Leone, but then you find some political influence also in the way and manner in which the selection of cases, the cases prosecuted by the court was done. You can refer to the situation relating to the former President Charles Taylor, the involvement of the United States even before the charges were framed. So there was also the relevance of politics in such situations. Now, if we come to the ICC, we will also see the relevance of politics in that. We have seen all kinds of negotiations that took place, including the review, which took place 10 years later, but still most of those powers are not part of this ICC. So it's because they believe that if they become parties to it, their political interest or their position will be affected by the operations of this court. And even those that have actually participated, they ensured that their interests were adequately protected in the way in which the statute was framed. We can make reference to Article 16, for example, which allows for deferral where the Security Council deems necessary. And also we can look at the article concerning complementarity of the ICC jurisdiction, which is actually also, in my view, political because those states ensure that they maintain absolute control over crimes which they may be found liable for if ICC is to assume primacy. Do I still have? Okay. Okay, so you see, if you look at the selection of cases by the ICC, you can see that the prosecutor, although independent, can determine the situation, can determine the cases to be prosecuted, but then the way in which that power is being exercised is equally political in nature. If we go back by the situation in Uganda, for example, only the rebel perpetrators were being targeted, whereas the same atrocities were committed by the state. You can also see the case of Kenya, which was a very remarkable situation of the influence of politics, and you can also see the case with respect to Congo. So in my view, what all this established for African leaders is the idea that perpetrators of international crimes do not prosecute themselves, do not prosecute when they are involved. So this idea was actually translated or transported to the domestic system, wherein you find you don't really, in many African states, you find there are really no legislative provisions for the prosecution of international crimes. No international institutions have been established with respect to the prosecution of international crimes. Even where those were established, like in the case of Uganda, you find that the courts were is susceptible to many political manipulations, has not been given the opportunity to operate in a way and manner in which it will efficiently function and address questions concerning domestic prosecution of international crimes. You find that only the rebels, and at least for the period that it has been there, for the number of years it has been there, only one particular case is before the court, which relates to the rebels. One person from the rebel, the LRA, and even though the state has itself committed many atrocities, but nobody from the state is being prosecuted. So that at the domestic level, the African state ensured that they copied from the standards, from the precedents set by the international criminal tribunals as far as the selection of cases are concerned and as far as the selection of situations are concerned. They ensured that only persons who are, they will not prosecute cases where their interests will be at stake. Some of them even ensure that they don't even have legal provisions because most of the times they are the ones who will commit those offenses. Now, when you look at also the application of the principle of complementarity there, you find a lot of problems. Yeah, because of time, I will have to stop.
I will ask you later to talk about how do you see the solution of all that.
Okay.
The point is very clear about the criticism and politicization. So I will keep some time for you later. Now, let's move to Rashmi.
Okay, thanks, President. I'll try and keep this very brief so as to allow comments later. I just have a few sort of illustrations that I think will feed into what I'm trying to create, which is an argument to explain the reluctance of India and Russia to be as passionate about applying the systems and the institutions of international criminal law to themselves as they have been in the past to applying it to others. And very simply put, I have two sort of theories about this, and I want to spend some time discussing those theories. The first one is the one that, let's call it a study of exceptionalism, and what that means in case of India and what it has come to mean in case of Russia. Obviously, I take the position of an outsider looking in, and so I'm open to comments on whether I got this idea totally wrong or not, which is very likely. So, the Indian idea of exceptionalism has post-colonial origins, I think, which is logically quite consistent with India's position at the International Military Tribunal for the Far East. Qasim was talking about the establishment of the tribunal, the position that India took, though of course it's by accident, it wasn't really a deliberate position of the Indian state as much as it was a child of the post-colony, Radha Binod Pal, who was accidentally nominated a judge on the tribunal by the Indian state that thought that he was a fairly neutral candidate to posit, and it turned out that they had raised the anger of the post-colony. And in Radha Binod Pal, you find this kind of latent, it's a commentary on the Indian position on empire, the Indian objection to empire, more than a careful or even scientific treatment of the prosecutorial mechanism of that tribunal, which I don't think was Pal's, the body of Pal's dissent is more about his opposition to the institution. And he embodies a whole generation of those opposed to institutions that were vae victis. The idea of vae victis, the idea that the conqueror has no rights, has now been vanquished, and politically they have no feet to stand on, and therefore all other states can claim a moral high ground over them, is the basis of vae victis. This is the point at which India and Russia are markedly dissimilar, I feel, because under the commander, under the rule of MacArthur at the tribunal and the appointment of the Russian member of the trials, my reading of the material seems to suggest that Russia supports the vae victis position, because Russia at the time was a story of empire.
Soviet Union.
The Soviet Union, at the time was a story of empire, which then, led to eventual politicization of what it meant to be exceptional in the Russian context. There's a very interesting comment that I found by a colleague in Russia who talks about Russian exceptionalism as being more or less consistent through Imperial Russia, Bolshevik Russia, Communist Russia, and the current state. And he talks about the idea that the deification of the state, which is such an important part of how Russian internal law understands the role of the sovereign, has never really been dissociated or never really undergone a fundamental change across the change of regimes in the USSR. And this, he says, accounts for what he calls hybrid exceptionalism. And I borrow that term to reflect on how Russia moves its position from a supporter of vae victis and how that is consistent with its rejection of international institutions at the domestic level. Now this point, the point of rejecting international institutions at the domestic level, is a point of similarity between India and Russia, because far from being allies on the creation of the International Tribunal for the Far East, And later, Russia sat as a great power. Qasim has gone into the details on the Security Council resolutions that created the institutions of the ad hoc tribunals. The ad hoc tribunals were part of really the via-victis game. It's possible to extend the via-victis theory also to certain pockets of violence in the 90s in East Africa and in the former territory of Yugoslavia. Because the creation of those tribunals alienated those who were stakeholders in the criminal justice process of those tribunals, which I think is Qasim's main critique as well of the tribunal, the lack of legitimacy, the lack of ownership. In other papers and work, I too have reflected upon the meaning of transitional justice in East Africa and how there is, how the creation of these tribunals, while jurisprudentially enriching, has contributed to what can be called an African approach to international law. And I'm happy to talk more about that later. It isn't really a part of my comments here, but essentially, it's not unique to either India or Russia to argue exceptionalism. I'm sure many here are familiar with the American exceptionalism idea. The African approaches to international law is one more example of exceptionalism. It's essentially a post facto academic analysis of why states are politically reluctant to put their weight behind regimes and institutions that they may support at the international level, but are reluctant to have applied to them. This reluctance comes from, so this is the second part of this. This comes from the idea of a need to harmonize or a support for harmonizing legal systems. Veselin started the panel by commenting about about Russia's support for harmonizing legal systems, which was one of the foundational motivations behind what came to be known as the Road to Rome, the creation of the ICC, the collaborative effort by so many states to join legal systems and to distill core ideas of criminal law to have applied to the new tribunal. But then you have Security Council Resolution 1422, and Russia and India, both of them are strong supporters of the process of deference by the ICC. Sorry, excuse my voice, I have a cold. This reluctance is very problematic. Separately from the panel, Veselin was talking about the Indian state's position on the ICC, which is in a position paper released by the Ministry of External Affairs, which talks about largely the disillusionment that the Indian state feels about the jurisdictional criteria of the ICC, which I feel is it's open to criticism, obviously, scathing criticism, and perhaps it's also misconceived because this isn't really how the Rome Statute was meant to apply. But if you look at the idea of complementarity, which is a hybrid principle of jurisdiction that was born in the Rome Statute, it was the response by many states to a rejection of compulsory jurisdiction or universal jurisdiction, which were contemplated as other bases for jurisdiction at the time of the adoption of the ICC. Yes, sure, it was a compromise, it was a hat tip to positivism, to international law's extremely statist bias, to say that states cannot be compelled to be called before the tribunal towards the permanent court. You cannot have compulsory jurisdiction, it won't fly. But part of that was also a safety vault. States that supported this idea created complementarity partly to make sure that they would never be subject to the court's jurisdiction without their express consent. And a reading of 1422 that takes into account this context of complementarity makes it quite clear that the state's reluctance is a practical, it's a prejudice to the ICC based on a practical rejection of the idea, of the alternate ideas of jurisdiction that could have been part of the court. So essentially, you know, these were my 2 points. One on exceptionalism, and the other on the idea of why victors and why states that have applied themselves so strenuously to creating these institutions at the international level are reluctant to have them apply at home.
Thank you, Rashmi. I will have some more minutes for you later. In the meantime, let's move on with Stephen Marks. Stephen, please get ready with your... He will display a few things, and in the meantime, let me just remind Kasim, I would like you to also comment for a minute about the possibility of an African regional criminal court, whether you see such an opportunity somehow to, not now, after Stephen, but just not what you describe as a problematic system now, ICC and ICTR. And also, I would like Rashmi and maybe Amit too, to think about what Tatiana asked, the issues of judicial errors and acquittals. She mentioned that acquittals are actually reduced in Russia. And I wonder what will your response be about the same in India, how Indian judicial system deals with acquittals, judicial errors, and appointment of judges, okay? And I would like you, all the panelists also to think about Article 17 complementarity. I hear different voices. On one hand, Kasim suggests that it's also part of depoliticization, because in a way, giving priority to domestic tribunals to try first, but within the international context of the ICC, may put some people in immunity and other people in jeopardy. So I wonder, it's a very interesting, I must say, I want to know more about this, how that works in a specific in a African context.
I want to talk about, actually what I'm leading up to is to ask you what you think about the prospects for applying universal jurisdiction to identifiable Russian pilots and military leaders who are behind bombings of hospitals in Syria. That's what we're leading up to. But to get there, I would like to briefly review the need for universal jurisdiction based on impunity, the principles of universal jurisdiction, its codification, and its practice in other settings. Thanks. So why do we need universal jurisdiction? Well, the underlying reason for it is, of course, impunity. We are trying to respond to impunity with a view in the broader perspective of protecting populations from mass atrocities. Now, the principles of impunity defined here were elaborated in 2005 by Diane Orndlicker for the United Nations, and they contain a number of really valuable, important principles. States should undertake effective measures, including the adoption or amendment of internal legislation that are necessary to enable their courts to exercise universal jurisdiction over serious crimes. The principles are in 3 parts. The right to know, that is commissions of inquiry, the right to justice, that is prosecutions, and right to reparation and non-recurrence. Now, one of the reasons why universal jurisdiction has been alluded to as being a necessary framework or option for criminal prosecution of those responsible for mass atrocity is that the prevention of those atrocities under Chapter 7 of the UN Charter have failed. Syria is a prime example. The Rome Statute is only working in the political setting that was described and does not apply especially to the countries we're talking about here who have not ratified it. R2P is also failing post-Libya for a number of reasons. So universal jurisdiction we need to look at as a possible way of approaching these issues. Its codification has been proposed by this project, the Princeton project on universal jurisdiction. It was a conference that was attended by some extremely high-level people, including the Undersecretary General of the United Nations for Legal Affairs, and Diane Ortlicker herself, and the head of the African Commission on Human Rights, and Michael Kirby, and Stephen Schwabel, and Michael O'Neill. Some really towering figures. And then there were a couple of ordinary mortals who were there as well, trying to help elaborate these principles. Now, these principles, of course, we don't have time to go over them. They enumerate these serious crimes, which is important to consider. Slavery, genocide, piracy, war crimes, crime against the peace, crimes against humanity, genocide, and torture. But what's important, one of the critical issues that I want to remind you of these principles is Principle 5, is that the official position of any accused person, whether head of state or government, or as responsible government official, shall not relieve such person of criminal responsibility. So, if you are the head of state, if you are a senior leader, if you are the Secretary of State or the head of Foreign Affairs, you are not immune from prosecution under universal jurisdiction. And we're not going to go into any of the other principles. We're simply going to move on. In the interest of time, I really regret now that I had to add these to be separately notified because, come on, hurry up. Of course, for the reasons that have been alluded to by all the previous speakers about the political influence of it, it has been severely criticized by people whose names are obvious to you, and taking the example of the United States, and in particular, one of the strongest critiques came from former National Security Advisor John Bolton, who had some very strong language about it. Human rights activists who view their morality as higher than that of elected governments. That's precisely why contemporary universal jurisdiction is so profoundly anti-democratic. It is time unambiguously to reject universal jurisdiction. It sounds like a term plucked from obscure international law, but has pernicious and profoundly anti-democratic consequences. So this is the politics that the previous speakers have been referring to. Well, universal jurisdiction has been tracked in the various cases that have been brought up. The latest edition of this publication called Make Way for Justice by an organization called Trial has enumerated, here's the 1917 report, and the latest report identifies 119 ongoing cases, an increase of 106% from the previous year. So Make Way for Justice is a compilation of the ongoing cases. Now let's look at three cases that are kind of worth considering. Universal jurisdiction, we talked about the politics and the failure to prosecute those for political reasons, and the failure of the United States, India, and Russia to ratify the ICC Charter. Well, so what do we do about somebody like Donald Rumsfeld, who has accepted full responsibility for the terrible activities that occurred in Abu Ghraib? One could conceive of France applying its universal jurisdiction law to Donald Rumsfeld. And so what in fact happened is that 4 NGOs complained against him for torture in connection with Abu Ghraib, Iraq, Guantanamo Bay, Cuba. And however, relying on an opinion from the Forest Ministry, the National Prosecutor of Paris dismissed the complaint on grounds that Rumsfeld had immunity. Well, that's a violation of Principle 5 of the universal jurisdiction, but as you pointed out, politics prevails here. Now, we don't have time to go into it, but the prosecutor's office has attempted to examine the situation in Afghanistan and the role of the CIA, but we're going to have to skip over that. And the sad result is that the prosecutor's office rejected the request to investigate that. Okay, let's skip on. And of course, the President of the United States and John Bolton were very happy with that outcome. All right, let's look at a second hypothetical. Modi. He has been accused by a citizens' tribunal of crimes against humanity and genocide. This publication of the inquiry into the carnage in Gujarat found him guilty what would happen, for example, if he went to Canada for a visit, and Canada applied its own Crimes Against Humanity and War Crimes Act. Well, in fact, he was examined by a Supreme Court appointed special investigation team, and they could not find enough evidence to hold him guilty. So the question here is that the Citizens Tribunal has found him guilty. The special investigating team found no evidence. What is the likely outcome of a case under universal jurisdiction? Consider that it's conceivable that in Canada that could happen. But we don't have a case. It has not happened. Now let me bring you to the one that I deliberately put in to be provocative. I hope I've established enough friends here so you're not going to hate me for having brought this up. There are many studies. Médecins Sans Frontières examined it. Recent studies by Human Rights Watch and Amnesty International referring to Russia-Syria war crimes in the bombing of Aleppo, Russia and Syria forces targeting hospitals. The Atlantic Council published a detailed study, of course referring to Russia's categorical rejection of these allegations, but it says that, contrary to claims by Russia aircraft used incendiary bombs in these hospitals. So conceivably, there is a case to be brought against Russia for this. The Violations Documentation Center in Syria has also documented the role of Russian forces in this matter. A UN panel cited evidence of the fixed-wing aircraft from Russia, and aerial and ground operations were carried out by Russian aerospace forces, damaging residents and civilian infrastructure. And this is the report of the Independent Commission of Inquiry. So there is some documentation available. The UN Relief Office has called upon the Security Council to deal with the carnage in which Russia allegedly has played a role as found by these various people. And in September, by the end of this month, a new 3-team member headed by Obiakor will start investigating the attacks on hospitals in Syria. So there's likely to be more evidence. And the organization called Physicians for Human Rights has published a recent report referring to Russia having vetoed the referral of war crimes to the ICC. National governments should aggressively pursue accountability through universal jurisdiction. This is the proposal of Physicians for Human Rights. So my hypothetical is, what if some of these jurisdictions that are considering, have applied universal jurisdiction, including France having captured individuals, beginning with Rifat al-Assad in France, under universal jurisdiction for the crimes committed against the civilian population in Syria. So 8 countries are applying universal jurisdiction in the Syrian case. Austria, Finland, France, Germany, Sweden have brought charges. Norway, Switzerland, and the Netherlands are conducting investigations. 11 Syrian cases have been examined. These all involve Syrian individuals over whom they have been able to exercise personal jurisdiction, and they're able to pursue the investigation. What will happen if, for example, Lieutenant General Audrey Yudin, Commander-in-Chief of the Russian Air Force, were to visit one of those countries, and some organizations like the ones that I've mentioned were to convince the prosecutor to bring him or other individuals to trial under universal jurisdiction for the claimed crimes committed against the civilian population in Syria. So that's my question to you. Does the politics prevail? And because, for the same reason that Russia, India, and the US are not parties to the ICC and are avoiding universal jurisdiction, that same reasoning is going to apply, and there's no chance of this happening. What will happen? Would it be a good idea for international justice or not? That's the question I leave you with. I hope I haven't gone too far over the time.
Thank you.
Then I'll try to finish in time. So I'm going, I will be largely focusing very on the domestic criminal law, the diversity of the panel, but I hope that the overall broader theme that I'll try to make would have some reverberations with the larger international law concepts. My presentation is simple. My argument is basically quite simple. The argument is largely premised on the idea of perpetuation. So what I try to argue is that there is a perpetuation of reign of terror in the name of cow protection, and the instrument that is used by the state is criminal law, and largely not known. But the focus which I would keep on my presentation is about the perpetuation, the continuation of the cow vigilantism, and not as exceptional or exceptional moment which we feel in the contemporary times that something new has happened. The Indian Constitution has this provision which talks about the protection of cow and the legislations. 2-3 things are important here, that it's in a part which is part 4 of the Constitution, which is a part which is not enforceable but merely directives to the state. It is giving directive to the state and not an enforceable fundamental right. Part of the reason for this provision to be in part 4, which is the non-enforceable part, was none other than B.R. Ambedkar, who convinced the Constituent Assembly that you cannot have this as a fundamental right. Part of the reason could also be because Ambedkar was somebody who was an undercaste, and the question of cow in India, which is made out to be something related to Hindu and Muslim, is actually more complicated, because within the Hindus it is also a problem because the undercaste were very much having beef as their staple diet in the pre-independence India, as the historians would tell us. The only 2 words which I'm interested in is preservation and prohibition. Way back in 1958, when the first Supreme Court case came before the Supreme Court, the first case came before the Supreme Court, one pertinent question was, what is the emphasis of Article 48? Is it preservation or is it prohibition? So do we need to have prohibitory legislations, or do we need to preserve? And the argument was quite simple, that the emphasis of the Constitution, the heads of the Constitution, reading the Constitution and the lists of the state legislature, are largely talking about preservation and improvement of cow, and not necessarily prohibition, not necessarily coercive sanctions. However, the Supreme Court way back in 1958, Indian Supreme Court decided that this question is to be left open, and today in 2019 the question still remains open and not finally decided, that whether the emphasis of the Constitution is preservation or prohibition. So prohibition got a good go ahead. I'll quickly tell you that this is the debate which we see if you read Indian constitutional law writers, or if you read Indian constitutional law historians too. The debate is about how in 1958 way back, the Indian Supreme Court told us that cows and calves are, a total ban on them is absolutely reasonable constitutionally. However, they made a distinction with cows and calves and bulls and bullocks, which they said that age and utility would determine that are they, can you slaughter bulls and bullocks or not, but cows and calves, there is no question. So if a state wants to totally ban cow slaughter, there is no constitutional prohibition on that. It's totally permissible. That was 1958, and then the most latest judgment of the Supreme Court is 2005, when actually the court decided that not just, so this debate got over, and the court said, not only cows and calves, but bulls and bullocks also can be brought in the total ban, because they read the Constitution as protecting cow progeny. This case became very famous actually, because the Supreme Court also approvingly cited a very famous quote where they compared cow dung to the famous Kohinoor diamond, and they said that's so important, so that's why there's no question of this debate. All these years, around 50 years, there was a full-fledged debate where states in India came out with fights because they would figure out that on the question of age and utility. So sometimes the states would push the threshold as high as 25 years for the prohibited animals, which might be the life of the animal itself. So there were litigations which went up to the Supreme Court, and the story went on. I'm not interested in this story. What I'm interested in the next 5 to 7 minutes that I have is actually what was not focused by the writers, which is that during this entire span, something else was also happening in the court, which was that all these laws which were brought by the court were not just limited to these questions, which were the constitutional questions, but there was also a coming up of criminal law throughout. So the word prohibition of the Constitution became actually a veto for all kinds of criminalization in the name of cow protection. And that's something that unfortunately neither the judicial discourse nor the scholaristic opinion tries to focus on. And that's what I would like to talk about it. So if I go forward, then I want to say that prohibition became the coercive criminal sanction. Coercive criminal sanction is important because Ambedkar was quite categorical that he wants to put Article 48 in Part 4 so that it is non-coercive. He was not interested in coercively making the issue of cow. But criminal law came in. Slaughter was made a crime. Transportation of beef was made a crime. Interstate as well as to other states. Sale of agricultural cattle was made a crime. And these crimes were quite stringent, cognizable and non-bailable, which are very Indian expressions for saying that arrests could be made without securing any warrant. And for bail, you have to go to the magistrate, to the court, unlike bailable offences where you can get the bail in the police station. So stringent criminal law went on. Further, the burden of proof, so not just substantive law, but even procedural criminal law, burden of proof was reversed. So instead of presumption of innocence, if anybody is accused for transporting, slaughtering cow, there was a presumption of guilt, that the accused has to disprove the case. And the Supreme Court of India in 1961 upholds this reversal of burden of proof constitutionally. Reversal of burden of proof constitutionally. And it is very interesting that not once in, say, these 40 years, the Supreme Court asked the question from the state that what are the reasons for such a stringent criminal law when prohibition could be obtained and attained in different fashions. Then, as I told you, 2005 Supreme Court judgment happened, the Kohinoor Diamond case, as I would like to call it. And then there was a spate of legislation that came across the states, criminalizing heavily all forms of cow slaughter and even possession. So for instance, I take two examples, there are many. One is the 2015 State of Maharashtra Amendment. Possession of the flesh of prohibited animal was made punishable. Again, cognizable and serious offense. There were mandatory minimum punishments which were added. 2011, before 2017, there was another amendment in 2011 when Narendra Modi was the Chief Minister of the Gujarat, and the minimum mandatory punishments were enhanced and no question was ever asked. 2017 is quite interesting, just 2 years back. Slaughter was punished with life, and 5 lakhs, which is like half a million rupees, were made as fine, exaggerated fine. Not yet questioned in the Supreme Court. Possibly things have become too normalized that we think it's absolutely fine. One wonders then why life imprisonment, and if life imprisonment, when you have such a high fine, why do we need this kind of a coercive sanction? Any other way is not understandable to you but to say that here is criminal law used as a repressive state apparatus. Very quickly then, to try to wrap up and come and been in a hurry because of the time shortage. 7 Supreme Court judgments there are 7 Supreme Court judgments since, say, independence around more than 70 years which have come on the issue of cow. Not a single Supreme Court judgment talks about the concept of over-criminalization. So not once the court said that why criminal law is used so lock, stock and barrel. Why criminal law? What is the purpose that is happening? Supreme Court judgments have come up to 2005, and even recent High Court judgments are available. No Supreme Court or High Court judgment even mentions the basic principles, despite the available literature of people like Andrew Ashworth. Across the world, there is a talk about against overcriminalization. Douglas Rusak has written a book. Ashworth talks about principal view of criminal law, how should be shaped, what should be the social significance, why should we not have criminal law? Never a court asks that. So it's very interesting if you read the cases of cow slaughter. It is just 1 or 2 paragraphs on criminal law and largely approving this is what it is fine. Nothing at all. That's a very interesting silence which takes the form of the state-sponsored violence in the use of criminal law. Despite the literature, Douglas Husak, Peter Ramsey has written a brilliant book called The Insecurity State, but it seems that nothing ever touched the Supreme Court on this issue. The use of criminal law became an obvious issue. Now this is quite interesting because why I say this about overcriminalization and not citing of literature, because if we go back, then we always hear that cow provision was a provision which was a very Gandhian gift and so on. Quite the contrary, because not just, not for many other reasons that the provision talks about modernity, which was anathema to Gandhi, but Gandhi always talked about non-coercive persuasive methods, while the use of criminal sanction sounds, and the way the Indian legislations have gone, sounds quite contrary. In fact, I was wondering that if at one place Gandhi and Ambedkar can stand together, then that is this, that cow prohibition should not be coercive. While what we see in the Indian Supreme Court and Indian legislative history is that there were strong coercive means. Finally coming to my last point, because my first argument therefore is that one has to look carefully at the judicial discourse, at the discursive judicial pronouncement to understand, to better understand that it is not an exceptional moment, but rather the seeds were sown throughout the Indian history, and the fruition is what we see, what we call vigilantism. But let's even go back to the Supreme Court, which is my final sort of point, to the Constituent Assembly debates actually. Because Constituent Assembly debates are also quite telling to say that even in the formative moment of the Indian Republic, we do not have much any different perspective, but rather quite similar to what you would find today in the contemporary moment on the question of cow. Let me take two of the founding of buffaloes which yield milk. So this is one person, Pandit Thakur Das Bhargav, who was arguing that no, not just slaughter of cow, but goat as well, buffalo as well should be there. So that's interesting. If we go back, then actually the ban can be expansive. The ban can be expansive and one can understand where the Supreme Court is going. Another important member of the Assembly, R.V. Dhulekar, was saying the Hindu society or Indian society has included cow in its fold. It is just like our mother, in fact more than our mother. At one place they said it is the mother of the nation. And it's quite interesting the way flattening of Hindu society and Indian society happens. Finally, one quote I would like you to see, which comes actually after this quote from Dhulekar, where he says, and I want to read this out, it's quite fascinating. I can declare from this platform that there are thousands of persons who will not run at a man who kill, that man who will kill their mother or wife or children, but they will run at a man if that man does not want to protect the cow. That's quite interesting. I wonder how many of cow vigilantes could say this today if they don't find the Constituent Assembly. Finally, and that's where I want to finish. I want to finish the last point that I want to make. The argument I want to make is that a careful look at the Constituent Assembly and a careful look at the judicial pronouncements tell us that the violence of cow vigilantism cannot be understood as an exceptional moment. Rather, one has to understand, if one wants to appreciate, is as a continuation right from the inception of the Indian Republic. As we have learned this question, that exceptionalism is a very seductive, exceptionalism is a very catchy idea, and we can fall for it. It's tempting because you want to say, oh, this is a bad moment, these are bad people. But one should not forget about the Holocaust. Agamben has to say that the Nazi Holocaust was not an exceptional moment, rather a continuation of the modernity. Otherwise, how do you explain colonization? Finally, I think Walter Benjamin is useful to be remembered when he says that no document of civilization exists which is bereft of barbarism. And I leave you with these questions that if we want to understand the violence, we need to look at the continuation. And I'll just read this thing that was my final conclusion. That criminal law is used as an instrument of repression, particularly but not only in constitutionally legitimized cow protection laws, indicating how the rule of law can simultaneously coexist with the reign of regime-sponsored terror. Any attempt to fully comprehend, to fully understand the contemporary outburst of the episodic violence requires an engagement with the formative, the Constituent Assembly, and the interpretive, the judicial discourse, practices of the past. And that's something which we need to do and think about.
Thank you, Amit.
Thank you.
Very well. I really appreciate